All right, good afternoon, everyone. Welcome to the last course in our Other State Mandatories webinar series. This one is going to be about professional engineering, the Practice Act and Rules for Indiana PEs, presented by Kevin Cito and Jennifer Callis. Just a few housekeeping reminders. We have sent out the PDH certificates for the past 2 webinars if you've attended them. If you didn't receive those, please email info@illinoisengineer.com and we'll get that settled. The handouts and the quiz are up on the website now. You should also see the handouts in the handouts pane of your dialog box there. We'll save questions for the end, and if you have any questions for ISP staff, go ahead and email the info@illinoisengineer.com. I think that's it. So, if you could complete the quiz by Monday, we'll have the certificates out by next Tuesday. All right, I will let Kevin and Jennifer take it from here.
Okay, thank you everybody for attending today. Jennifer and I are very pleased to present to you today on the PE Practice Act and Rules for Indiana PEs. This, of course, is the second hour of PDH for those of you who are licensed in Indiana. And our goal is to go over things in that respect. So, who are we? Well, you've been listening to me drone on for the last 2 weeks, but I've invited my partner, Jennifer Callis, to come back. She and I have done these now maybe 2 times, if not 3 times in the past, every other year. So we're kind of old hands at this, I don't know.
Yes, we are.
But you've seen me before here. Jennifer, tell us a little bit about yourself.
I've been practicing for 24 years in the area of civil litigation, and I've handled a multitude of cases involving personal injury in relation to engineering related cases, and I've been in our Hinshaw, Indiana office since 2002.
Okay, so our learning objectives today. It's good to have an idea of what we're trying to cover here. We want you to know more about the Indiana PE Act, have a sense of purpose, and I'm going to be trying to point out to you some of the differences in Illinois and Indiana. We assume all of you who are participating today have a dual license, that you're not licensed just in Indiana, but also in Illinois, and the hope is I can point some things out. You know, one of the first ways to get into trouble, quite frankly, in fact, is to make the assumption that the law is the same in both states. And it's true that the laws of physics and science are certainly the same in both states, but that doesn't mean that the laws are by any stretch.
So there are various sources of Indiana law for professional engineers. And you can go to the website that you see on the screen here, and it's a page that's dedicated solely to professional engineers. And it has a lot of information about how you maintain your license. It's got an FAQ section that answers some common questions. You can also search disciplinary cases that have been brought by the Indiana Attorney General for violations of the rules applying to professional engineers. And it's pretty well laid out, and the state of Indiana just redid their website, and so I think it's a lot more user-friendly than it has been in the past. So you can always start there, and that will direct you to the statutes, which you can see on the screen are codified in the Indiana Legislative Code. Specific to engineers, there's also a Uniform Standards of Practice Act that applies to professionals in general. And there are also rules that are codified in the Indiana Administrative Code by the governing body for the professional engineers in Indiana. There are also court decisions from the Court of Appeals, from the and the Indiana Supreme Court related to the conduct of engineers. And then, as I was mentioning earlier, there's decisions of the disciplinary body on Indiana professional engineers, and you can search an engineer by name or license number. If you want to, you can also do the same thing to look at the disciplinary history of those engineers by name and license number. And you can also go online and see if someone you're dealing with is actually a professional engineer and has a current and active license.
Which is not at all unlike Illinois. In other words, they have a so-called license lookup on the Illinois Department of Professional Regulation so that members of the public could, of course, quickly discern whether or not someone who claims she's a PE really is and go at it from there. To back up one slide on that one internet address, I guess we'd call it, that says compilation blah, blah, blah. That is a handout which Ariana has put up on her website, I believe. So you could look at that. That's a good place to start here. Now, one of the first ways to look like you don't know what you're doing is to call yourself a licensed a licensed professional engineer in Indiana, because there they are considered quote unquote registered, whereas in Illinois, a PE is licensed. And I pointed out for those of you who licensed and registered in Wisconsin that the word there is registered. Oh, it may not make a whole lot of difference, but it would be nice to at least be able to have the jargon down straight, especially if you're trying to make a fine point with a client, an architect, or a contractor. At least get your story straight about who you are. One of the questions that always arises is registration at the corporate level. For Illinois, we have businesses that are quote-unquote registered. See, Illinois uses both words. Registered as a quote-unquote professional design firm. And that's if they are offering professional engineering or structural engineering or architecture or some combination of the three. And the only exception in Illinois about that registration as a professional design firm is when a sole practitioner is using his or her own name, like I've indicated here, John Doe PE. But as soon as you start talking about an assumed name or Glen Ellen Professional Engineers or some other name that's other than the sole proprietor's own name, then that is a problem if you're not registered as a professional design firm. Not that big a deal, but it's certainly something that has to happen. And it's something I have found that out-of-state firms, somebody gets a commission and they're located in New York, let's say, and they come in and they don't appreciate that there's the need to register as a professional design firm.
Okay, moving on to the next slide regarding can you use the designation of PE retired, and Indiana does not have a statute that provides for that. And use of the initials PE after your name are limited to the time and place of your registration. So unless and until you have an active license, you cannot use that designation, even if you designate yourself as PE retired. So unlike a academic degree like MD or JD or the like, you are not allowed to use that designation. And you're only allowed to use the PE initials if your license is active and current.
So the key thing, and I've made this point in the last 2 weeks, is that Illinois does allow a PE to say that she is a professional engineer, retired, and of course the person cannot practice in that retired mode, and that has not yet been adopted in the Structural Engineer Practice Act of Illinois. And it doesn't exist at all in Indiana. So if you are no longer paying your registration fees in Indiana as a professional engineer, then that's it. It's as if you never were one as far as titles go. So that brings us to this Topaz case, which is an amazing case. You know, if you look at what I've got there, Topaz versus Oregon Board of Examiners for Engineering and Land Surveying, and did a Google search on that, you'll come up with the opinion, and it's a pretty interesting thing. In the Topaz case, they summarize it by saying that the person was a landowner, this Stephen Topaz, and he used to be licensed as a PE in the state of Maryland. Well, he wrote a letter complaining to the Board of Examiners, of all people, about the city's sanitary sewer project in front of his house, and he didn't like the way it was being done. Well, the Oregon Board of Examiners undoubtedly immediately looked to see if this Mr. Topaz held a current PE license in their state, and they quickly discovered that he did not. So they put a fine against him of $350, and he didn't take to that, and they said, well, you're engaging in the practice of engineering without an Oregon license. And he basically said, oh, come on. I was a PE back in Maryland. And they said, well, that may be true, but that's not the point. And the question arose, well, why did you send the letter and put your initials PE at the end? And he said, this is in the court opinion, it might be, the board might be easier to receive a response, and there might be some better action from the board if they determined that he had some professional training and knowledge relating to the issues in question. In other words, we might say that he was quote unquote competent in that area. Well, the board still didn't take to that, and they were not interested in his experience in the state of Maryland when he had moved out to Oregon. Make a long story short, they upheld the fine and kind of boxed his ears a bit, and basically he said that's just not going to work in our state. Now, that Topaz case was in 2012, 2013 or so, but then we have the case of the Swedish engineers, we're calling him, in 2017. So the question was, or arose in this fashion. This gentleman, Matt Jarlstrom, his wife got a ticket in Beaverton, Oregon, and he thought that the traffic lights were not timed correctly. Mr. Jarlstrom was no foolish person in the sense that he had schooling and considerable education and knew a fair amount about electricity and things of that sort. So he investigated it and claimed that he, as an engineer, could determine that the lights were not timed correctly. But when he declared himself to be an engineer and had studied the light sequences and otherwise had looked into it, he too was fined $500 by the same board, and he then in turn took it up as a free speech issue and claimed that they were trying to stifle his ability to protect his wife from a traffic ticket. The board, though, basically took a much simpler approach, and that is they were basically saying, look, you can say whatever you want, get on your soapbox and criticize all you want, but whatever you do, don't make it sound like you're a licensed professional engineer when you're not. So this is not the end of these matters, but and if you Google his name and any combination of things, you can read more about it. I have for you here the U.S. News and World Report article about it, and you might, if nothing else, get a chuckle. But it does show, though, that state agencies will take people to task when they are using this word engineer too loosely when they think it approaches on the practice.
And many of you probably already know the reciprocity rules because you're likely dual licensed in Indiana and Illinois. And so there are two ways that you can seek reciprocity in Indiana. You can be certified by NCEES, and the next or has several components, and they all need to be complied with. 3 years engineering work experience and passing a similar exam that's related to Indiana, and be registered/licensed in another state for 10 years.
Yeah, we expect that most of you have done it this way. Perhaps you began your career licensed in Indiana and came to Illinois. Who knows? But the point is, all of this is out there, and the good news is that at least reciprocity is available in Indiana. So, what is the practice of engineering? We've laid this out to you in some detail, and the reason is that, to borrow a terrible analogy here, sort of a I know it when I see it, all of you know what engineering is as a practical matter, but here's the definition that we find in the statute. And you might say, well, let's see, this looks pretty broad, and the answer is yes, it is. But notice on this slide the 4 points about how you'd be applying engineering sciences, as they say, in the fields of consultation, no surprise there, investigation, probably no surprise, evaluation, well, sounds a lot like investigation, maybe, and then planning, including the use of land and water. But it goes on to say, designing or supervision of the design of engineering works and systems, and so forth. The point that we're trying to get at here is it's a fairly detailed definition that they're giving you here. Notice in subparagraph 6 the somewhat fine distinction made between surveying activities to support engineered projects versus surveying of real property for land boundaries, rights of way, easements, and that sort of thing. Probably a decent distinction, and one that I think in the field probably has no significant issues, but you know, keep this in mind. Our purpose today is to keep you as up to tune and up to speed as possible about what the laws are for Indiana PEs. And so certainly it would seem that you ought to know how Indiana defines the practice of engineering. I, for one, think that Illinois engineers ought to go back and read their Practice Act, but there is no requirement as such.
And there is a provision in the statute that defines what the practice of engineering is not, and it does not include the work ordinarily performed by persons who operate or maintain machinery or equipment. And so people that we may think fit into this category are maybe an operating engineer, a railroad engineer, a building engineer, or a stationary engineer. So you're allowed to use that designation as long as you're limited to operating or maintaining machinery or equipment.
And of course, you know, the better practice would be that someone would say stationary engineer as opposed to just engineer. But we think this ought to be pretty workable over the many, many, many decades that this has been the law. Investigation is something that I find a lot of people don't seem to appreciate as fully coming within the definition of professional engineering, and more importantly, the need to be duly registered in Indiana in performing quote-unquote investigations. So in that respect, you know, even an out-of-state quote-unquote investigating engineer needs to be registered in Indiana. And here I've made a bit of a slip. I should have said registration, not licensure, is it encompasses more than just design work. Sometimes people want to take a telephone call and start giving advice about an investigation. And our point today is to point out to you that you're really walking on eggshells, if not violating the law, when you start talking about an investigation if you're not registered in Indiana.
And the statute specifically tells you what you are to attach your seal to, and you may seal plans, specifications, studies, drawings, and reports. So typically when we think of applying a PE seal to a document, it's plans or specifications. But if you do any sort of a written report that has no plans or specification, but it encompasses however engineering is defined under the statute, you can attach your report to it. You can attach your seal to a report as a professional engineer.
And I think that's very important. I think it's important on a bunch of levels. Those of you who have listened to me in the last 2 weeks have heard me say that I once had an engineer say, well, if you don't put your seal on the report, you can't be sued for malpractice. And the answer is the same today as it has been for the last 25 years. The answer is, of course, you can be sealed. And on top of it, if you don't, you could be sued. And on top of it, if you haven't put your seal, you violated Illinois law or Indiana law, as the case may be, because reports require seals. The other thing, too, though, that strikes me about it is that it's a great marketing thing. Your client has paid you a fee to come up with this report, and now you're applying your seal and showing that they're getting their money's worth. They're getting, you know, it's not like you attach a blue ribbon or a big red ribbon or other some crazy thing to it, but I mean, the least you could do is put your seal on there and show that this is not just any old letter that somebody wrote. So what does it mean when the seal is there? It's important for you to know this because this can easily be overlooked. It is that you're attesting that it's your engineering work or someone who is your subordinate that you supervised, and that it's work that's prepared under your control and direction. And look at number 3, you're assuming full professional responsibility. And number 4, that it meets the standards of acceptable engineering practice. Well, that's all important stuff right out of the statute. And so, you know, various things flow from that, which we're going to be covering here. But the key point, though, is you're saying this is you know, at a minimum, acceptable engineering practice, and it's your professional responsibility. That shouldn't be a surprise, but this is where people can get into trouble if they haven't, in fact, done the requisite supervision. Now, as far as applying the seal, notice where it says Rule 864. This is a rule, whereas the previous one was a statute. Statutes supersede rules if there's any inconsistency. Rules typically just embellish the statute, as we see here. And notice perhaps the obvious thing. You can put your seal on there only when your certificate of registration is current. Well, that shouldn't be a surprise. But if you were suspended for whatever reason, because, well, like here's a simple example. Your registration, let's say, is due January 1, and you have not got your act together, and it's now February 1, and you still haven't sent your check in to re-register. And in the meantime, somebody wants to apply your seal to a set of drawings or report or what have you. And if your certificate is not current, well, that could be a problem. Now, I'll grant you most of the time nobody's going to be the wiser, but on the other hand, it does illustrate if you didn't pay by the due date, you're arguably not current, and you better lock up your seal for a couple of weeks.
And in preparing for the seminar, I did some looking around on the website that we previously talked about, and although the Attorney General doesn't file that many complaints against PEs, just in a survey I looked at for the last 10 years or so, a lot of the complaints that were filed by the Attorney General are related to either expired registrations or someone was an intern and never updated their status to professional engineer. And it's very easy to check on the website to see if you are current in your registration. And I can't say if that's how these engineers that didn't have current licenses were vetted out for discipline, but that seems to be one of the more common ones.
Well, I agree, and it's so easy to check for the Attorney General.
Right.
It's just so black and white, you might say. Now, one thing that we want to emphasize, too, that's a distinction between Illinois and Indiana is on this same slide about when you're not in responsible charge of the entire work. So let's assume just for the minute that there's a set of some 50 sheets, and say 20 of those are various branches of engineering, and you're happening to do the electrical work, sheets E1 through E6, let's just say. Well, you'd seal E1, E2, E3, E4, E5, E6, no problems there, but you would also put your seal on the title page, but you would make it very clear that your work was limited to, for example, as we show here, covering the electrical design, or frankly, I'd amend this slightly and say covering sheets E1 through E6 exclusively. so that no one could think for a minute that the M drawings or the S drawings or whatever were somehow yours. But that's very important and something we really lack in Illinois. Now, one of the things, too, that's a distinction for Indiana over Illinois, and I think it's a real plus, is this recognition of pre-designed manufactured equipment. So you're specifying, let's just say, an air handling unit, or even something as mundane as a garage door opener system, or much less pumps or other common manufactured products. Here, they're saying that you can include those without having designed them, so long as it meets these 4 qualities. Now, that seems to me to be pretty straightforward stuff. We could get into some finer points if you were designating, let's say, a Hilti anchor system, which might be seen as affecting the structural safety of the project, let's just say. And you guys, I'm sure, could come up with better examples than I did just off the cuff. The point I'm getting at is that might be something that you do need to be more careful about. But going back to my idea about a pump, an air handling unit, or something like that, at least Indiana recognizes that you can put your seal on drawings that show those, or drawings or specs which show those products or equipment, and not have to go any further.
The statute also provide, or the administrative regulations also provide you with instructions on how your seal is to look and how big it is supposed to be. And the example that's here on this slide is not from the Indiana website, but the one that's, there is an example under the FAQ section of the website we previously talked about that shows you what your seal is to look like. And I'm sure all of you know this because you're actively licensed. So if you want to see the official one that the state of Indiana represents, you can find that on the website.
One also wonders, too, where they find all these fictitious names, you know, at least John Jones and John K. Jones, not John Doe or Jane Doe or something. I don't know. One wonders, but whatever. Moving right along.
And the administrative code also provides you with information as to what the seal is supposed to look like, and one important aspect of this is that you can reduce the size if you need to, as long as it can as long as it remains legible. And you can also apply it embossed, which is typically what we would see with like a subpoena or some kind of a notary press. You can also sign it electronically, or it can be applied with a rubber stamp, and then you have to have certain information on the seal that corresponds with your certificate number. And basically the point of your sealing your plan documents is that you as the professional engineer are taking the last look at the work product and certifying that it meets professional engineering standards endorsed by you as the professional engineer.
One thing I want to draw your attention to is how the seal can be electronically applied, even though you would otherwise be signing it in ink. I've seen quite a bit of distinction from one state to the next about the electronically applying seals. And frankly, let's assume for the minute that you were going to be doing a project in Oklahoma or Montana or Wisconsin. The point I'm getting at is you'd want to read their rules and statutes very carefully to make sure that your seal could or may not be electronically applied. This is again one of these things where you don't want to take for granted that just because we do it this way in Indiana, that somehow every other state does it the same old way. It's just not that way. Now, supervision, control, and direction. You know, we talked about this last week with Wisconsin about how they've got these elaborate definitions, which I think are very appropriate and important and detail very nicely what these terms mean. Illinois doesn't do as good a job as we might hope on this definition, for better or for worse. It's sort of understood, well, it means what you think it means, you might say. But certainly, though, plan stamping in every state, you can bank on this, is not going to be permitted if you've put your seal on drawings not prepared by the practitioner or under your personal supervision by your regularly employed subordinates. Now, this might seem okay, but and straightforward, and certainly we all understand the idea that if a contractor brings in a roll of drawings and says he needs a building permit, and would you just put your seal on them, and I'll pay you $50 or even $500, the answer is, even if it's just the plans for a doghouse, the answer is you can't put your seal on there, because if you didn't prepare them or if they weren't done under your supervision while they were being done, not after the fact, then that's just not permitted. And imagine a situation then where somebody joins a firm and she's asked to seal the drawings that were done by perhaps competent people at her firm, but were done before she arrived. You know, this points out that that simply can't be done. Or you're at a firm and there's, let's say, 15 competent people, some of whom are licensed, some are not, and then they hunt around and say, wait a minute, Jennifer, you're licensed in Indiana. Would you seal these drawings, please? And poor Jennifer is put on the spot in the sense that she didn't do any supervision on the job, and yet she's the woman holding the Indiana license and suddenly is asked to seal these things. It's a difficult situation. Now, strictly speaking, the answer is no, I can't do that. I can't do that in Indiana. But what about, though, if we're going to talk about what can happen in Illinois, but what about in Indiana? Can you substitute for another PE?
Well, in Indiana, there's no statutory provision for that. So if you haven't supervised or done the work yourself, you cannot apply your seal to the documents. And Kevin and I were talking and preparing for this, and it actually gives you as the PE some leverage and ownership over your work. And the example that we were talking about is if you get halfway through a project and your client's not happy with what you're doing, or there's a dispute over fees, for example, it's costing too much, or whatever the fallout might be, but your client has maybe half of your plans, or maybe the project's almost complete that you're working on, can that person then say, well, I'm ending my relationship with you, I'm taking what you did, and I'm going to go to another PE to finish the job because I don't like you or your work anymore? Can that second professional engineer use any of those other plans or documents? And the answer is no, unless that person was involved in the drawings that have been developed, or the plans or the report that's been developed to date, or unless that person was involved in the supervision. So you actually have some leverage in that regard, that someone won't be able to steal your work. That's right.
If the other engineer in Indiana is doing the the lighting, let's say, and you did something else that also happened to be electrical but wasn't the lighting, I suppose maybe that's a fine distinction. But let's say your design is 80% complete, and then the owner wants to have somebody else finish the remaining 20% for some reason. I don't see how that's possible under the rule. Now, here's the thing, though. Illinois has very different rules, and different than Indiana, and they even have different rules for each of the 3 disciplines in Illinois. I've laid out for you the references there so that you can read what the differences are, but suffice it to say, like for Illinois PEs, if the original PE for an Illinois job, forget Indiana for a minute, if the original PE relocates, becomes disabled, much less dies, then there can be a successor PE, but that, as we're pointing out, that's just not something that they've thought about in Indiana, or at least they haven't chosen to address it. And given the silence, our opinion is it just simply cannot be done. Now, I touched on this briefly. What about the corporate practice? I pointed out in Illinois, there has to be a registration of a professional design firm for everybody, including professional corporations, everybody other than a solo practitioner who's using her or his own name. But what about in Indiana? Well, first of all, they point out only natural persons may be registered. That's no surprise. But a PE can practice as an employee of a business. And no surprise with that, too. Now, Jennifer's going to comment about the Secretary of State of Indiana. But the key thing I want to point out, though, is that you have to have a full-time employee of the business who is the registered PE. And this is a quick way to get in trouble. If they find out that you've got a retired person who's coming in 1 day a week, that is not going to cut it. And probably not even 3 days a week is probably not going to cut it.
And if you practice as a legal entity and not just as an individual, as a corporation, for example, an LLC or an Inc. designation, in addition to having a PE license, you also have to make sure that your corporation is registered with the Secretary of State, and you can also do the same thing if you're a professional corporation or a professional association, but you have to remember to also maintain that corporate form and comply with the registration laws in Indiana to operate as a business organization.
That's a key point because, as I mentioned, a lot of out-of-state firms will come into Illinois, and they know, just like all businesses, that you got to get registered and pay the franchise tax and what have you. With the Secretary of State, they don't appreciate, though, that they have to register as a professional design firm. And Indiana is no surprise. They're saying, well, you got to, if you're licensed in Illinois and want to do work in Indiana, just like if you were doing anything, selling widgets or whatever, the point is you have to be duly licensed as a foreign corporation.
And one other thing I would add is practicing as a corporate entity is smart because if you follow the corporate forms and you keep your license and your registration current and you do whatever you need to do to maintain that professional organization under the law, it insulates you from personal liability, potentially.
Except in negligence cases, in the sense that just like if you go in for surgery and the doctor makes a mistake, the doctor's on the line no matter how many professional corporations. But certainly for contracts, and this is a subtle distinction, and our advice always is, though, have the corporation. It's always better than not. The cost is so limited, and every inch you can get of better protection is only for the better.
Right. You just have to make sure that you actually, even if you're a solo person and you're the only member of the business organization, you still have to go through the motions and keep the records that you need to demonstrate that you are, in fact, operating as a business organization and not as an individual.
Have an annual meeting, for example.
Yes.
Pay income taxes as the corporation goes, as the case may be. So just to take another look at what you're sealing, here it's laying it out in the statute. Plans, sheets of designs, reports, studies, all this kind of stuff. And it's got to be the registered professional engineer who is in responsible charge of the project, of the work, not somebody who just happens to have that Indiana license in your office, but who otherwise didn't do anything. I've counseled some engineering firms, when that person is going to seal it, make very certain that that person who is statutorily in responsible charge is billing time to the project. Sometimes they'll say, well, I'll just walk over and have Louis seal the drawings. Well, if Louis never charged any time, assuming that you're working on an hourly basis, it really looks really poor when you claim that Louis was giving all this supervision and being in responsible charge if Louis has never even put any time down on the job.
With respect to public projects, there's a statute that provides that counties, cities, townships, school corporations, or other political subdivisions must have plans and specifications sealed under the direct supervision of a professional engineer. And one thing Kevin pointed out is school corporations in Indiana are...
Yeah, just what are those? We don't have those in Illinois.
They're basically a governmental entity that oversees a school corporation. They're separate legal entities from, say, a town or a city, wherever the school corporation might be located in. And so basically, if you're doing any work for a governmental entity in Indiana as a professional engineer, this statute, I guess, it's kind of duplicative of you can't do engineering work anyway without being a professional engineer, but this specifically says with respect to government-related work that they are not allowed to accept or approve any specifications that are not prepared under the supervision of a registered professional engineer. And one of the cases that I ran across when I was looking at the Attorney General disciplinary cases was actually somebody who was stupid enough to submit plans, drawings, or specifications on a government-related project, and of course, pursuant to the statute, whoever was in charge of accepting those plans probably went on the website and realized that the person who had submitted the bid and the specifications was not registered in Indiana, and so that person then was disciplined by the Attorney General's office.
And rightly so. I mean, I don't know what they were thinking about.
I know. I don't either. I was really surprised to see that.
I mean, it's kind of flaunting it. It kind of takes us back to our Mr. Topaz in Oregon, writing to the Oregon Board of Examiners. Oh my gosh, of all people to write. It's one thing if he were writing the letter to the newspaper, but whatever, moving right along.
And sort of dovetailing on the government previous slide, if you work for a governmental entity, you cannot use the word engineer in your title unless you actually are a professional engineer.
So I can picture a large city, or perhaps even a village, handing out the title village engineer or city engineer or something like that, and it could make somebody kind of a feel good and they look good and all that kind of thing. But the point that they're trying to say is there is no such thing as a village engineer unless that person is a registered professional engineer. And this is good, I think, and it the hope I should say is that use of the term is not diluted by all these wannabes.
So what can happen if you practice without a license? Well, as we talked about, you can be disciplined by the Indiana Attorney General's office, and your license can be suspended, revoked, you can be put on probation, etc. Other things that practicing without a license may lead to are an injunction, which is somebody goes to court and gets an order that says you're barred from working on this project or continuing with your work because you don't have a license.
Or barred from continuing to advertise that you're a quote-unquote engineer when you're not.
Right. You could be criminally prosecuted under Indiana statutes for holding yourself out as a licensed or registered professional when you are not. If you have an ongoing project that you are working on and someone discovers that you are not licensed and your client's already paid you for what work you've already done on the project, there may be an inability for you to ever get paid for that work that you did because you shouldn't have been doing it in the first place. And so anything that you might be owed or have already been paid, you may have to repay to your client if they discover that you're not licensed.
In Illinois, we've had several cases on this disgorgement of fees and recovering unpaid fees. There was an architect, Gregory Tabb, T-A-B-B. You could Google that poor gentleman. And he was told that he could not recover his unpaid fees because although Mr. Tabb in Illinois for an Illinois project was duly licensed as an architect, there was no question about that, he had failed to register his firm as a quote-unquote professional design firm. The unscrupulous developer found out about that and refused to pay the unpaid fees. Mr. Tabb went to court and lost. Now, subsequent to that, there have been half dozen other cases, The Illinois Supreme Court held in a case involving a podiatry firm that they didn't think that was going to be upheld any further, that failure to get licensed was really more of a problem between the state government who wanted to collect the fee and the individual as opposed to developers or clients or people out there. A little bit like if you were driving without a driver's license and had failed to renew your driver's license. It's, of course, illegal to drive without a driver's license, but if you get into an accident, I don't think it makes any difference whatsoever. It's not like the person who was injured because you ran a stop sign gets double damages or something crazy like that just because you weren't licensed, didn't have a current driver's license at the moment. It's still the same standards, and that's kind of what the court's saying. Yes, you need to be registered, of course, but you still get to collect your fees. The developer or what have you doesn't get a windfall.
One other thing, what Kevin was saying just reminded me of another interesting disciplinary case that I ran across, and it had nothing to do with embossing signs or plans, drawing specifications. It was an individual who, and I'm guessing he was retained as an expert witness in a civil case, and he signed an affidavit in support of something that was filed with the court. And I'm assuming that the other side, in vetting him and checking the expert out, went on the website and discovered that he was not a current professional engineer under Indiana law. And so, based on one line in an affidavit that this professional engineer signed that said he was in fact an Indiana professional engineer, somebody found out he wasn't, and he was disciplined because of it. And that had nothing to do with plan stamping, or it was just the fact that he had those two initials at the end of his name and represented under oath that he was in fact a professional engineer when he was not.
Well, that's an interesting point, Jennifer, because in Illinois we had a case where a plaintiff in a road accident case hired a professional engineer from the District of Columbia who came in, gave an opinion and an affidavit in this wrongful death lawsuit of the motorist against the engineering firm. And he never represented that he was licensed in Illinois, but the engineering firm defendant said, yes, that's all true. Thanks for being that much truthful, but you can't offer even an opinion in a court of law if you're not licensed in Illinois. Well, the Illinois Supreme Court dealt with that by saying, well, we'll figure that out on a case-by-case basis. And Mr. Engineer Defendant will take care of that. That's not for you to worry about. But it's an interesting thing. Some states say, don't even think about being an expert unless you're licensed in our state. It's, again, something to be very careful about. If the phone rings and you're getting a call from another state and you're not licensed there. And
what reminded me of the tale that I just told was that may be another situation where if somebody retains you as an expert and then the court bars your testimony because you're not licensed or registered in whatever state you're giving testimony in, I can bet that the engineer in my example probably had to refund the fees because he was whatever he did as an expert, because he wasn't registered in Indiana, and he should have been.
Right. Key point here, it's not on the slides, but if you're going to be a consulting expert or actual testifying expert, I would say get licensed ASAP. Now, professional engineers are exempt from the practice of architecture. What that really means is when you're purporting to practice architecture, in other words, you don't have to be licensed as an architect to be a PE. Well, everybody knows that. And it also means that an architect can't use the term engineer unless actually registered as a PE. But this idea that PEs might somehow be able to practice architecture without being an architect, I don't think it goes that far. That is not the situation. And of course, if you use the word architect when you're not, obviously that's going to bring sanctions. That's no surprise. I mean, goodness, that's hardly the situation one would want to put herself in.
So what happens if you run across somebody who you believe is an architect or a professional engineer who has violated the law or is guilty of obvious malpractice? Can you report it to the governing board without fear of a defamation lawsuit? Can you post it on social media with any sort of immunity from any defamation lawsuit? If at the end of the day, the licensing board determines that there's no wrong.
And bear in mind, you know, we talked 2 weeks ago about the obligation of a PE to report certain things in Indiana. If she thinks that there's been this malpractice or knows of a violation of ethics rules, there's this duty to report. So what happens if you report it and you in good faith think that there's been a violation, but the board, for whatever reason, concludes that there's really not a problem after all?
And in Indiana, as in most states, if you defame somebody related to their profession, office, or occupation, if it's untrue, defamation is a matter of law, and they don't even really need to show that they've suffered any actual damages or out-of-pocket money. You could be subject to a civil lawsuit. So you have to be careful when you criticize any colleague in the context of a written or an oral statement. And in the days of social media that we're in now, you have to be very careful what you post in writing and in the public domain about coworkers, colleagues, other practitioners, because if you do anything that maligns their occupation, it can be very, very dangerous.
Very dangerous. You know, I've seen many lawsuits in Illinois where surgeons one will accuse the other of being incompetent. You know, I wouldn't let them operate on a dog, and other kinds of outrageous comments. And of course, lawsuits follow from that pretty quickly. There was a lawsuit in Illinois a while back, maybe 10, 12 years ago now, where an engineering firm wrote to a contractor's surety saying that the contractor was incompetent. Well, that resulted in a lawsuit. The engineer lost, and the damages were presumed by the jury. The jury was told, go ahead, award the damages. Well, they did. They awarded both compensatory damages because the guy lost his bonding capacity, and punitive damages, and none of those damages were deemed covered by the engineer's insurance policy. So it was just a terrible, terrible nightmare of a situation. So is there a defense?
So in Indiana, as long as you have made a sworn or written statement without malice, meaning without ill will or intent to harm somebody's reputation or business, to a regulatory board, or in the course of investigatory hearing or review proceedings, you have immunity. So the key point to remember about that is it's talking about sworn or written statements. So
telephone calls,
telephone calls, postings on social media, letters, anything outside the investigatory hearing or review proceedings are not protected. So
for example, if you make a sworn statement or a written statement to Illinois Society of Professional Engineers, well, that's the written statement. The telephone call is very dangerous, of course.
Right.
In fact, it shouldn't even be made. But here's the key thing, though, made without malice. Jennifer, expand on that just a little bit, because how do lawyers look at this, and are they going to just roll over and say, oh, I'm sorry, I'm sure it was made without malice. Sure, we'll dismiss the lawsuit.
Right. I mean, malice is a pretty high standard to show that somebody acted with malice. So I think as long as you have a good faith basis to make a complaint.
I agree, but here's the problem. Whether or not there's malice or not can be the subject of many depositions. It's not something where the judge just bangs the gavel and says, oh, this case is thrown out. Oh, no. It's going to be depositions and well, wait a minute, you're a competitor to the person about whom you complained, and you'd like to see them put out of business, so you'd have all the work.
Right. Yeah. There's a lot that can be thrown at you to show malice, and no one really knows without getting in your head. But Kevin's right. To get to that point and to figure out what your motivation was for making a complaint is going to be a lot of just a lot of depositions, written documents, and headaches for you. So you just have to be very careful when if you are going to complain about somebody to the regulatory board, and certainly be very, very cautious outside of that proceeding, because it's very easy for somebody to file a lawsuit against you.
Absolutely. This is America.
That's right.
Mandatory insurance, not needed in Indiana. Reporting malpractice judgments, not in Indiana or Illinois. Be wary about other states if you're practicing there. Just to wrap this up, I'd like Jennifer to comment a little bit about how Indiana is different than Illinois as far as litigation goes.
Yeah, in Illinois, it's pretty easy to, if you don't respond to a lawsuit in a timely fashion, nothing bad will usually happen to you in Illinois in state court. But in Indiana, and certainly in federal court in either state, timely response to a lawsuit that's been filed against you is very important. So as soon as you get that summons, you've got a limited amount of time. And in Indiana, it's 20 days. In federal court, it's 21 days. I think was it 30 in Illinois?
Yeah.
You've got to immediately go to your insurance agent and
really
find out who to report to, and follow up with your agent if a lawyer's not contacting you, because sometimes things get mishandled at the insurance agent level. Or if you know who your malpractice carrier is, report it directly to them, and then follow up with that entity to make sure that someone's intervening on your behalf.
Because otherwise they enter an order of default, which means that you just admitted to everything that's in the complaint. You're not contesting the complaint. You're agreeing that there can be either a prove-up of the damages, or that you're agreeing if they asked for like $82,100, let's just say, for a breach of contract, you just, as a matter of law, agreed that you owe $82,000 or whatever.
And in Indiana, unlike Illinois, you can be served with a lawsuit by certified mail. So if you get something in the mail, don't assume, oh, well, the sheriff didn't deliver it to me, or somebody didn't hand deliver it to me as a process server. No, if you get it, even if you get a courtesy copy just by regular mail, as soon as you are aware that someone has initiated legal action against you, you've got to contact your agent or whoever your carrier is, if you know who that is.
Absolutely, absolutely. I mean, that's a huge distinction between Illinois and Indiana. Now, we've got our bios here at the end, so you can look at us. But at this point, though, Ariana, do we have any questions here? We appreciate that we're very close to the end here.
So we have just one question so far, but while we're answering this one, if anyone has any more, go ahead and type them in now. So here's the first one. Why even have a difference between licensed and registered? Why not be consistent with the language?
Well, because that's a good question, but it's a relatively simple answer. The legislature in Indiana does not consult with the legislature in Illinois, and that's just the title that they decided to use. And all across our states, some say tomato and some say tomato. I don't know. I mean, it's one of these things, and you just would want to be careful to try to use the right words so you don't look like a carpetbagger if you're going to Indiana.
Okay, and we have another question. Is it possible to hire a draftsman to make a CAD drawing for me if I don't have any of my own draftsmen?
Oh, I think so, but you've got to give them that personal supervision and, and look at their work over the course of time and answer questions as they may arise. That sort of thing. I think that's perfectly permissible. Of course, what they're really looking to avoid is the after the fact situation where somebody just says, here, do this and give it to me, and I'll sign it and seal it at the very end. So I think that's perfectly appropriate.
Okay, and a next one. Does Indiana define an engineering investigation versus a fire investigation?
I'm not aware of any distinction in that respect. And so there are, of course, fire investigator type people. And I think if the fire investigator said, for example, this fire got out of control because the sprinkler system was under-designed or the sprinkler system failed, I believe that that fire investigator, who may have investigated, for all I know, 200 cases of arson, is treading on very dangerous territory, if not going past his expertise. And I'm just using that as an example, like the sprinkler system, because as we know, that could easily fall well within the gamut of a professional engineer's design skills of figuring out, the size of the jockey pump, the diameter of the pipes, blah, blah, blah. So I think that gets to be in that touch and go area, but just like a professional engineer would want to be careful about investigating fires if it gets beyond, strictly speaking, engineering.
Okay. Another one. Why can building engineers and operating engineers use the term engineer?
Well, because that's what the statute says. It's just one of those things. Like a locomotive engineer, for better or worse, in our country, in my opinion, the use of the word engineer has been a generalized word for a long time. And unlike architect, where we don't say licensed architect or registered architect or professional architect, tend not to do that, the use of the word engineer seems to have been a much more generalized word, and then the profession as a whole realized it would be good to elevate stature by saying professional engineer, and that part is good, and that is protected without doubt. The difference is, though, they're still allowing people to be operating engineers, stationary engineers, and things of that sort, and do so without being quote-unquote professional engineers.
All right, well, that looks like that's the last of our questions. So, Kevin, I just want to thank you, and Jennifer, you as well. Thanks for taking the time out of your schedules to do this today. I know we all really appreciate it.
You're welcome.
If you guys can have the quizzes done by next Monday, I'll get you your PDH certificates by Tuesday. Like I said, the handouts and the quiz are both up on our website. If you guys have any questions for me, you can go ahead and email the info email. And I think that's all. So have a great rest of your week, everybody.
Let me just say very quickly, we appreciate the opportunity and look forward if you have any questions going forward in the future on these areas. And also, too, I'll give a plug. I don't know of any organization that gets out the PDH certifications faster than Ariana. You're really fast.
I appreciate that.
Okay,
right,
thank you. Bye-bye.